Good afternoon, everyone. Welcome to the second session of our workshop. Welcome back to those of you who are here this morning. So we're continuing our discussion on the constitutional protection of minorities, and the focus for this afternoon's session is the individual and collective approach to the domestic and international protection of minorities. Our organization is going to be essentially the same as this morning. The speakers will have 30 minutes to speak on their topics, and we'll have a break between 4 and 4:30. We'll have a break, so I think that's all I need to say, and we'll begin with Professor Palermo, Francesco Palermo.
Perhaps, well, I'll better stand, although in my case, whether I stand or I sit, there is not such a big difference, I'm afraid. Well, no, as I have prepared a PowerPoint presentation. Yeah. Oh, no, okay, it's fine. If I see people falling asleep, then I will stand up and try to, I'll leave it here. Well, first of all, thank you for inviting me to this highly challenging and stimulating conference. I'll try to present some additional food for thought, although you know, the subject now is slightly different as compared to the one we had this morning. I will try to briefly talk about essentially 5 things. First of all, it's, you know, a general question as to why we are talking about essentially an European instrument in a conference which is devoted to protection of minorities in Asia. Then I will briefly look at the Framework Convention and its background and its approach. Then I will see how it has developed in practice, which is not immediately, you know, following the text of the provisions that we'll try to demonstrate. What's wrong with that? Okay. Then we will see how this document has been recently interpreted in order to make it a really valuable and effective instrument, and the reactions that are coming to that new way of interpreting this instrument. And I will try to make some, again, bridge to Asia and see to what extent there is, or there might be something in for Asia, but also from Asia for the European mechanism. Now, first, very briefly, why talking about the Framework Convention? Well, the most obvious answer would be because Roberto has asked me to do so, and I will just, you know, follow his instructions, even though I was not entirely convinced that it was a good idea. You won't be either after my presentation. Well, there are perhaps also other reasons. One is, of course, that the Framework Convention is, as is known to all of you, I guess, the only existing instrument worldwide devoted explicitly to the protection of national minorities. So it's the only binding instrument, the only existing treaty, and therefore it has at least the ambition of being, you know, of an importance that stretches beyond European borders. Secondly, there is always, not only in literature but also in the political discourse, an issue about a possible export of European instruments, and mostly the Framework Convention. There is also a lot of debate about the possible export of other instruments, such as the High Commissioner on National Minorities of the OSCE, because it has such a security mandate also to other non-European areas. But the Framework Convention also contains a specific provision, which is Article 29, which expressly opens it to ratification by non-member states of the Council of Europe. So far, it has not been the case. This might be one of the reasons why this instrument might end up in a crisis, because the process of ratification has slowed down and basically has stopped for the last 10 years or so. But there is a debate about that, and perhaps there can be something also in that for the discussion. And not least, as we are comparative lawyers here, I think this debate has also something for, comparative lawyers, in the sense that, it can be an interesting test in terms of what is comparison about, especially when we try to work as comparative lawyers. We always have to try to avoid the temptation of looking at what is on paper and try to compare that, because then in the end it's a relatively vain attempt, while it is important to know how instruments really look in practice and how they really work in order to see whether or not there is any possible basis for comparison. So I will try to do that exercise with regard to the Framework Convention, how it looks like and how it is in practice. So my second point, the background of the Framework Convention. You all know, after the 1989 revolutions, especially east of Vienna, there was a challenge for Europe in general, but also, I would say, and much more problematic in a way, a challenge to the Western legal tradition as we knew it before that, when it comes to the protection of human rights. And as minority rights are human rights, they are human rights which necessarily have a collective dimension, which kind of, run in counter of the traditional approach of human rights since 1948, since the Universal Declaration of Human Rights, which is normally based on individual rights, a purely individual rights approach. So where do minority rights with their inherent collective dimension fit into that picture? Well, a problem also in terms of, structural, architectural design of this type of rights. Now, what happened as a reaction to that? Well, essentially two things were made in Europe. The first was the security approach, typical of the OSCE. Okay, let's see minorities not so much from the angle of human rights, but as a potential threat to security of people and of states. Let's try to address them under the security perspective and see that, to grant some rights to minorities is also in the best interest of the concerned states, because if they don't do that, they get troubles. The other approach is more sophisticated, because it departs from human rights and is, an attempt to put together the traditional individual rights approach to human rights with the collective dimension, which is part of the minority rights. So it was a sort of a, collective exercise approach to human rights that remain individual rights, but, they can only be exercised in community with others, as the language of the Framework Convention reads. Now, is that true or not that the approach of the Framework Convention is only individual? I would rather say it's not true. I mean, of course, it is in general terms. The Framework Convention did not subvert the conceptual paradigm of the Western legal tradition with regard to minority rights. Yes, minority rights are human rights. Yes, human rights are individual rights in essence, right? But the drafters went as far as possible in, trying to put a collective dimension into that and to overcome the dichotomy between individual and collective rights. They did what I would call the maximum possible stretch of the individual rights approach towards an accommodation of collective claims. For example, if you read the language of the Framework Convention, you find, all these difficult compromise exercises, like Article the whole text speaks of persons belonging to national minorities, so clearly an individual approach. But at the same time, Article 3.2 says that these rights enshrined in the Convention can be exercised individually as well as in community with others. Especially then, a bunch of 3 provisions was inserted in the Framework Convention, which was absolutely essential to the functioning of the machinery. But as we will see, they, got neglected, especially in the initial years of monitoring and of implementation of the Convention, which are Articles 4, 5, and 6. Article 4 speaks of the right of equality and of positive measures for minorities as such, so something which goes beyond the mere individual dimension. Article 5 says that the states have an obligation to provide the conditions for the effective exercise of minority rights and for enjoining, the conditions in general. And Article 6 speaks about all people living in the territory of the state, irrespective of whether they are to be considered or not as national minorities, as people who are involved in creating the conditions to protect minority rights. So a very important societal approach. The enjoyment of minority rights is only possible if certain societal preconditions are given, not only if some specific rights are granted on paper. Well, as I said, this approach was neglected, especially in the early years. Again, one instrument based on a purely individual rights approach, then one would imagine that it would have some individual complaint mechanism, and it's not the case in the Framework Convention, so this leads towards a more collective type of approach. But certainly, especially in literature, and as you are all familiar with that, I mean, I think that, as some people say, including Sia Spiliopoulou-Ockermark, for example, that probably the dichotomy between individual and collective rights is simply wrong. I mean, Michel will probably, elaborate further on that. Is that really true, or is it just that there is a wrong assumption of a possible conflict simply because one thinks that if there is a conflict between an individual and a collective right, then for some reason the collective dimension must always prevail. But this is absolutely not true and undemonstrated after all. So why should the collective dimension prevail? Like any possible conflict in law, then you might have the prevalence of one or the other depending on certain circumstances. Well, what happened next? That's already the 3rd point out of 5. Not the societal dimension was put under the spotlight, but rather other priorities were chosen. First of all, in the initial phase, of course, it was essential to secure the enjoyment of basic fundamental minority rights for persons belonging to national minorities. If you don't have the right to use your language, if you do not have the right to get instruction in your mother tongue, if you do not have the right to freedom of assembly, if you don't have the right to use your name according to the traditional way, I mean, there is very little to say on top of that. So you first need, of course, to establish the basic fundamental guarantees. After that had happened, in one way or another, somewhere better, somewhere worse, the whole debate actually focused more on the definition issue rather than on the instrument. And that was per se problematic, because then, of course, this all generated a sort of a very negative spillover effect when referring to the discourse about minority rights. So, which was, of course, made even more problematic after the beginning of the new millennium with the whole issue of migration, which again spoiled the whole debate. Now, instead of seeing minorities as an enrichment of society, minority issues were seen as a sort of a cake. I give you one slide of the cake, which means I have one slide less. So this, started a very, very negative effect, and also looking at who is to be considered to be a minority. Oh, the Framework Convention doesn't contain a definition. Thanks God, of course it doesn't, and it wouldn't be possible to do so. But of course, a lot of criticism about that, saying, well, then of course it's all about defining who can have access to the cake and who can eat a piece of that cake. So not enriching society, but making the society poorer by giving out some cake, right? This is something that, is very similar to some Asian trends that you especially have brilliantly described this morning. This created a very conservative, and I would even say even wrong, reading of the Framework Convention as a whole. First of all, minority issues were seen as something only affecting minorities, right? Which is like saying, gender issues are something only affecting women. I mean, is there anything more stupid than that? Well, but with regard to minority rights, well, in a way, this sort of assumption was, majoritarian. Then, of course, there was also a sort of a interesting logical spillover, saying that, of course, it is about individual rights, but individual rights are, very difficult to claim. It is essentially then also about groups, but groups do not exist. And therefore, you have a sort of a political battleground about group rights by people who exist only as people and not as groups, and they, of course, as groups are trying to make political claims, which means, of course, okay, better a political battlefield than a real conflict battlefield, but ultimately it's about, taking and giving. It's not about the society as a whole. It's about, you getting richer, me getting poorer. And this whole phenomenon, never stopped and actually became even worse with the whole issue of migrants. If you enlarge the scope of application of the Framework Convention, you eventually will include the migrants. Migrants are, becoming more and more. We are becoming Islamic society, as you have told us this morning, which is exactly the same dynamic also in many European countries. And therefore, we do not want to give out pieces of cake to migrants / Muslim, etc., black, and so on and so forth. That's more of the political, societal side. With regard to the purely legal side, there was also a consequence in that, which is the presumption of homogeneous groups clashing with other homogeneous groups. Majorities are homogeneous, minorities are homogeneous, they clash together. If minorities are powerful enough, they will get something, some piece of this cake. If not, they don't get anything, of course. And again, there is the presumption of, a framing majority-minority relations as, a conflict between two different homogeneities. And this is utterly wrong, of course, but if you frame it this way, then, of course, having the wrong diagnosis, you also end up having the wrong therapy. And the wrong therapy is the climate of suspect. Language laws in many, many countries demand, trying to limit the realm of minority rights, demanding loyalty by minorities. Minorities are, kind of supposed not to be loyal per definition. The issue of territory, this morning a lot of debate was about federalism and ethnic federalism. This is completely also spoiled the discussion of federalism means giving ownership to a specific group of a territory. As I normally say, this is not the first time I use this metaphor, but if the nation state was already utopian and quite a ridiculous construction in the 18th century, to think of a nation region very homogeneous in the 21st century is even less credible. So, but this is the way it is framed. Federalism means ownership of a territory by a specific group, and so on and so forth. Now, the final point is what has happened since, the 4, 5, 6 years maximum. There was, of course, awareness of these worrying trends coming up, and making the instrument less and less useful in order to resolve minority issues. A triad of soft law, rather important interpretative instruments were adopted between 2012 and 2016. These are two thematic commentaries to the Framework Convention. Again, not a binding document at all, but very interesting ways of reading how the Framework Convention must be read. And the Ljubljana guidelines issued by the OSCE High Commission on National Minorities called Integration of Diverse Society. So not even the term minority is in there, right? It clearly shows that, you know, you have to get out of this dichotomy, individual versus collective, homogeneous versus homogeneous, and look at society as a whole. Minorities are something that affect the whole of society. They can be an enrichment for the whole of society. So you need to reach out to majorities as well, because also majorities need to be involved in the creation of the societal preconditions. Remember Article 4, 5, and 6, which only make possible enjoyment of minority rights. These documents are trying to really reframe the whole identity paradigm. And they challenge this assumption of homogeneity, which actually is not written in any document, but has been implicitly, you know, considered. 10 left or 10? Oh, yeah, well, I'll be done in 3. But since I have so much time, then I can perhaps even quote a couple of articles from these documents. So they really challenge the idea of majorities and minorities equally being homogeneous groups. And you can read, for example, this is from the Ljubljana guideline number 5, saying that individual identities may be multiple, multi-layered, contextual, and dynamic. So it's about, you know, recognition of pluralism and the minorities being a fundamental factor of enriching the pluralism of society, which is a value per se. So we are already moving into the issue of legal pluralism, as was already mentioned this morning. There was something that I think it was you, right, Professor Malagodi, this morning, mentioning the issue of hierarchy. This is, you know, if taken from the perspective of classical Western legal individual rights-based tradition of human rights, is, you know, blasphemy, right? You cannot say that there is a hierarchy between groups, between rights, between, no, everything is equal. Roberto is an intellectual son of the French Revolution. We all are in that respect. So, yes. Well, even this very delicate topic was, you know, challenged here, saying, for example, this is paragraph 8 of the thematic commentary number 3, unequal power relations between different groups may lead to societal hierarchies that can also be reflected in language practices and political discourse. Well, not all the groups are in fact equal when we talk about rights, when we talk about minorities. Or does anyone really claim that, you know, Roma in Bulgaria and Danes in Germany are the same as they are national minorities? Come on, it's about hierarchies, and these hierarchies are, you know, utterly challenging society, but they are present. If we ignore them, I'm not sure we are doing a favor to our providing answers and solving problems in society. So all these sort of challenges were put on the table with these documents. Although I must say, so far there has been quite little impact on the debate. The debate still evolves around the issue of definition of who is a beneficiary of minority rights, of who can eat part of the cake. And, you know, this dynamic I tried to describe before, expanding scope of application. If you do not define, you immediately expand the scope of application. If you expand the scope of application, you end up including migrants. If you end up including migrants, you end up making our society ultimately an Islamic society, or something like that, as you very brilliantly described this morning. Okay. Now, Asia. Well, Asia is already a geographical concept, and as we have heard this morning, there are many different approaches to these issues in different countries, so it's difficult to speak about Asia in general. But if some general conclusions can be drawn, well, I would say that at least the legal instruments that have been developed to cope with diversity in some Asian societies are far more sophisticated than the European ones. Doesn't mean they're better. Can also be, you know, much more dangerous if you have more powerful instruments, and if you use them the wrong way, then the segregative exclusionary effect might be, you know, multiplied, which is what happens in many, many cases. Well, you know, Rohingya, you mentioned them this morning, and many other cases. The language that is often spoken in Asian societies is not that of minorities, but that of communally divided societies, right? So I think in that sense, even if Europe does not use so much this terminology, I mean, this is what is actually in European minds when we talk about minorities. So perhaps there could be a common benefit by looking at societies as a whole, and by acknowledging that minority rights are only possible within, you know, a common shared public space where diversity is respected and considered an enrichment for all. So especially looking, as these recent documents are trying to do, at integration of societies as a whole, rather than looking at integration of supposedly homogeneous groups into supposedly homogeneous majority societies, can be of some help. Of course, you know, there can be some cross-fertilization. There can be at least a discourse, first academic, then who knows, perhaps also political, in terms of using or cross-exchanging instruments. But this can only work if, of course, the right approach and the right meaning of the instruments is given. If the analysis is wrong, if we see the Framework Convention, for example, and other instruments as something only to protect homogeneous groups, possibly then in the end tall, blonde, blue eye, and rich, because then that's where it leads in the end, right? Then I guess there is very little in for Asia. If we see these documents as it has been recently interpreted, well, perhaps it is an instrument, one piece of the whole picture for legal pluralism, which is, I tend to agree with Roberto, the theoretical framework in which this discourse should take place, knowing what we are really talking about and not what we imagine that we are talking about. This is the big challenge for comparative lawyers. Thank you very much.
Thank you. So our next speaker is Michelle Staggs-Kelsall, and she's going to address the individual approach to protection of human rights in the ASEAN Declaration. Thank you.
Thank you, Pamela. And thank you all for being here this afternoon to join me in this discussion, and to Professor Tognati for inviting me. I'm absolutely delighted to be a part of the group and to be engaging in such a rich and interesting debate about minority rights, both in the domestic country context as well as in the regional comparative context, as Francesco and I are now embarking upon. Now, I recognize that I'm in the death session, the one after lunch, where everybody is tired and doesn't have much energy, so I'm going to try as much as possible to keep this punchy. I'm going to put a timer on now for 25 minutes for myself and hope to keep to that timer, but you'll hear it go off, and then I'll give myself a maximum of 5 more minutes if I happen to go beyond that. But hopefully I can stick to my own deadlines. I'm usually quite good at that. Okay, so just to begin to give you a little bit of situating where this paper is coming from by telling you just a small piece of information about myself. I am an ethnic minority group from Malaysia. I am one of the others that Jacqueline very kindly referred to this morning in her slides. Yay to the others. I was Anglo-Indian at birth and grew up in Malaysia and left Malaysia for Australia when I was 6 years old and have subsequently travelled much of the world, so consider myself a global citizen. But nevertheless, just to say, I am myself a minority, which didn't actually occur to me until much later in my life, that that's actually my own positionality in these discussions and debates, just to be reflexive about where I'm coming from. Like Francesco, when I was asked to look at the individual approach to protection of human rights in the ASEAN Human Rights Declaration, my initial question was, is it an individual approach? In part because I think there are aspects of the way in which the declaration has been drafted which show it to be somewhat of a hybrid instrument. But essentially, what my paper argues is that the ASEAN Human Rights Declaration adopts an approach to the protection of human rights which combines express commitments to protect individual rights with an acknowledgement that in certain circumstances, states can subordinate those rights in order to protect the rights of groups. And groups is a very important element of what I'll be discussing today, because the group rights I think it seeks to protect are those of the family in Article 19 and other articles, and the nation, which of course is a very, as you say, problematic term in Article 34. So it's not collective rights per se, it's a group right, and I'll explain the distinction between collective and group as I move on. So taken together with a very broadly constructed limitations clause in the instrument, what we end up with is a declaration that basically gives ASEAN member states authority to place the moral standing of groups above that of the individual when it comes to the nation or the family, which gestures toward an approach to the evolution of human rights in ASEAN that favours a statist conception of rights and that is deeply conservative. I think in this respect, amongst others, the ASEAN Human Rights Declaration has been criticised as a regressive step in establishing a regional human rights regime in Southeast Asia, because it fails to adopt an approach to human rights protection that places the individual rights holder above that of the nation state. It gives ASEAN and the declaration supranational authority. And it's also further disappointing in that it appears to favour selectivity of rights in the way in which it frames the rights over innovation. So in other words, it takes certain aspects of the Universal Declaration of Human Rights and then further reduces what those rights actually mean, which is also seen to be very problematic. And also enables governments to assert again the rights of the nation and the family at the expense of individual rights. Now, this is particularly a problem for all of you here today who are interested in the rights of minorities, because essentially the narrative of identity, to draw from Mara's discussion this morning, is one in which unity is very much prioritised over diversity and can essentially enable authoritarian regimes to utilise the instrument to their ends rather than to respect that diversity. So over the next 20 to 25 minutes, I'd like to explore the two ways in which it's been argued that the individual approach to protection has been adopted in the ASEAN Human Rights Declaration, how it came about, and how we can view this instrument. And I say that there are essentially two ways, if we look at the historical context of when the instrument came into being, that we consider why the instrument is as it is. Now, one way to view it would be to say it's a kind of endology approach, to draw from both Francis Fukuyama and Upendra Baxi, who very much used this term to great flourish in his work. And that essentially says the ASEAN Human Rights Declaration is the end point of a human rights journey that began at Vienna with the Vienna World Conference on Human Rights in 1993. And it's a 20-year story of how ASEAN governments grappled with incorporating human rights into the regional system in a manner that was endogenous to Asian values and the ASEAN way. And from this perspective, many authors have argued, Nicholas Doyle, Catherine Renshaw being two, that essentially it's failed. The approach has failed because the ASEAN way and Asian values have severely limited what the declaration can do. A second way of viewing the instrument would be to say that this is a foundational moment in the ASEAN human rights system. So in that sense, the document almost starts to get the episteme of a myth. It's the beginning of something. It's an origins argument, essentially, which the Philippines drafter from the working group who drafted the instrument calls it the ASEAN Magna Carta of human rights. And from this perspective, the declaration is not the beginning of the end, but the end of the beginning. So it's the start, really, of ASEAN's journey toward building a bigger regional system that's endogenous to the region, that takes on these ASEAN values, but also has a character of its own that's going to ensure the autochthonous notions of human rights subsequently emerge. And viewed from this latter perspective, the conservative approach adopted by ASEAN governments can also be viewed as a telling instance of how international human rights law emerges in its foundational moments to safeguard the political and security interests of the states, building the system. And in this respect, although it has been claimed that it's an approach emblematic of Asian values, in fact, it's not that different to what happened in Europe post-World War II. And here I'm really drawing from Samuel Moyne's work on The Last Utopia, for those of you who are familiar with Moyne, when he essentially says, at the time the Universal Declaration on Human Rights was drafted, it was essentially a moribund instrument that very few people outside of core group of international lawyers really cared about. It was almost a flourish by great powers to say, well, you know, we want you to decolonize, but essentially we want to continue certain neo-imperial agendas, but we'll give you human rights as a way of securing some form of response to the claims and demands that post-colonial peoples were making. Pretty good, I've got 16 minutes left. So that's the basic broad brushes of the argument. On the one side, we have end times, endology, this is terrible, ASEAN is clearly just a fig leaf for authoritarian regimes. On the other side, we have, this is a regional system, all regional systems start somewhere, it isn't the best, but bearing in mind the Universal Declaration of Human Rights didn't take off until the mid-1970s, when Amnesty and other organizations in Europe really saw human rights as having some moral and ideological purchase within societies in Europe. It's up to grassroots organizations and civil society within ASEAN over the next 15 to 20 years to really see what they can do with this instrument. So, before I go back into the history to show you how these two competing narratives play out, I wanted just to turn immediately first to the instrument so that we're all clear on what it is we're talking about. Now, I'm assuming that given you're doing a course on Asia, you know quite a lot about ASEAN, but just to give you the typical regional snapshot, ASEAN stands for the Association of Southeast Asian Nations. It's a regional association of 10 governments in Southeast Asia. Would you like me to give you all 10, or do you know who they are? Shall I list them off? So, Singapore, Malaysia, Indonesia, Thailand, Cambodia, Laos, Myanmar, Vietnam, the Philippines, and Brunei, Dar es Salaam, are the 10 governments. It has a combined gross domestic product of 2.4 trillion US dollars, which makes it the 7th largest economy in the world. It's a home to a plurality of religions, languages, and peoples that is almost too difficult to express in the 1.5 minutes I've allocated to it. But essentially, to give you a snapshot, over 300 different languages are spoken in Indonesia alone. So it's a very highly, highly diverse region. And the ASEAN Human Rights Declaration was signed in 2012 by the 10 heads of the ASEAN. And it comprises 40 articles that encompass general principles, civil and political rights, economic, social, and cultural rights, the right to development, the right to peace and cooperation, and the right to peace and the cooperation in the promotion and protection of human rights. And I will go into some detail again, just so to make that clear. So essentially, what do we mean when we say individual rights in this declaration then? And what do I mean by group rights as opposed to individual? When we're talking about individual rights, I think we're all clear that we mean rights held by an individual by virtue of being a human being. Now, collective rights are generally seen as rights that are grounded in the interests of those who jointly hold the right as a collective. So, in other words, to give an example, as a Hmong person in Vietnam, have individual rights, but I also have rights as part of the collective of the Hmong. Now, there's a distinction then between that kind of collective right and what I argue is more of a corporate idea of a group right, where the group itself it becomes a kind of legal fiction in which the rights of the group, as a group, not as several human beings, are more important than that of the individual. So, in contrast, giving moral standing to the group as such doesn't allow for the claims of the group to be analysed as those of claims of individuals. And in the Human Rights Declaration for ASEAN, what this does is it allows states to assert that in certain circumstances, the rights of the family as family, or the rights of the nation as nation, are more important than individual rights. So to give you an example from the declaration itself, so you understand what I'm getting at, in the section for which one gets economic, social, and cultural rights, the entire section ends with Article 34, which says, ASEAN member states may determine to the extent which they would guarantee the economic and social rights found in this declaration to non-nationals, with due regard to human rights and the organisation and resources of their respective national economies. So in other words, the state itself can determine how non-nationals within that state, whether or not they get rights, and to what extent it uses its economic resources for those rights. So in certain instances like that, I'm arguing that the language of the declaration places these rights as paramount. In terms of the rights of the family, the article in that instance states, the family as the natural and fundamental unit of society is entitled to protection by society and each ASEAN member state. Men and women of full age have the right to marry on the basis of their free and full consent to found a family, dissolve a marriage, as prescribed by law. So again, the family unit is paramount, and you can have the right to marry as long as our laws allow for it, which, as you can see, again, subordinates the notion of the individual person having rights as group or collectivity to that of the group of the family as a whole. So essentially that's what the ways in which, two of the ways in which I think these group rights emerge at the expense of individual rights. I wanted to briefly go through who the individual is then, that the ASEAN Human Rights Declaration is in fact seeing as this universal individual, right? Because as we all know now, the personal is political, and the political is also quite personal. So understanding how this universal individual in the ASEAN Declaration compares to the Universal Declaration on Human Rights, that individual. So just to give you a brief snapshot of who she is, and I'll say that she's a she. First and foremost, I must say that she has to be a she or a he. She's definitely not transgender, according to ASEAN, because there are no rights for persons who are part of either transgender or LGBTQI communities, and which has been very much too much chagrin for parts of civil society. She does have equal recognition before the law in the same way the UDHR, the Universal Declaration, declares. She does have the right to an enforceable remedy. She does have the right to be free from slavery and servitude, including trafficking, which is not mentioned in the universal image of the individual. She does have freedom of movement, and she does have the right to asylum as long as it's in accordance with state law. So again, somewhat subordinated from the Refugee Convention. She does have a right to nationality, again, in accordance with state law, which is different to the Universal Declaration, which continues to make it supranational. She has the right to freedom of religion, but she doesn't necessarily have the right to choose or to practice or to teach, profess, or worship her religion. But she does have the right to be free from violent discrimination. She has the right to peaceful assembly, but not to association, necessarily. She has the right to found a family, but again, this is prescribed by law. And she is not going to be exploited through child labour, which again is a novel clause that's not found in the UDHR. And if she's suffering from a communicable disease, including HIV/AIDS, she may have entitlements, more entitlements than found in the universal side of things. But in all of this, also, she's somewhat subordinated to the rights of development. And here we see very much a managerial approach to the right to development emerging from the ASEAN Human Rights Declaration. I would argue that this approach is not consistent with the General Assembly resolutions on the right to development that preceded the document, but rather more with the Millennium Development Goals and the Agenda for Sustainable Development. And one of the concerns, I think, that is raised when thinking about the way in which ASEAN got to the point it has got today, is to what extent the rights that are being asserted by this instrument are in fact trade-related, market-friendly human rights, to borrow from Upendra Baxi again, who, as you can tell, I'm a big fan. Because what we see in this instrument towards the end of the instrument, basically from Articles 35 to 40, is this move towards seeing human rights as basically a managerial process for the state in which it undertakes programs to ensure that rights are being respected, very much in accordance with what one could argue is palatable to moving toward a market-based economy in some instances, or maintaining its trade links and investment links with a number of Western governments and multinational corporations. So that's a snapshot of who the individual is in the Declaration. I just want to return in the last 5 minutes I've allocated myself to give you just a brief overview of how we got to this point and the two ways, as I began talking about, that we might view this somewhat quasi-managerial yet also rights appropriating document. And as I said from the beginning, the whole notion of Asian values and the ASEAN way, very much if you look at the journey taken from 1993 to 2012, one way of looking at that journey is to say that it was essentially one in which ASEAN continues to position itself vis-à-vis the international human rights system as a distinct regional system that results ultimately in the failure of ASEAN to embrace supranational human rights norms in the way that has been arguably prescribed by the international human rights system. So if we look at it from that way, what one would say is, well, and why 1993 is a focal point is essentially because at the Vienna World Conference on Human Rights, a number of Asian nations got together and signed something called the Bangkok Declaration, which basically espoused the idea that Asian societies had a different understanding to human rights to their Western counterparts, which prioritized economic, social, and cultural rights, and therefore Asian values need to be seen as distinct from Western values and Western human rights systems. And one of the main proponents of this was Singapore's first Prime Minister, Lee Kuan Yew, who argued that Asians have little doubt that society with communitarian values, where the interest of society takes precedence over that of the individual, suits them better than the American model, to quote from Lee Kuan Yew. So basically that story says that Bangkok was a low point for Asian adoption of the international, supranational understanding of rights-based norms. And from that, ASEAN then went on, however, to develop the ASEAN Charter in 2007, which gave legal personality to ASEAN in the region, and as part of that included a provision stating that it would have an ASEAN human rights body, and subsequently that it would have this declaration. So the high point then becomes when we have discussion in 2007 about the possibility of this human rights body, this supranational body that would instill supranational human rights norms in ASEAN, but that what subsequently happens is that the Intergovernmental Commission, which is established, is essentially not given any power to hear complaints from individuals, and therefore the supranational idea of human rights and the rights of the individual that were still a possibility from 1993, in fact, become the dream. Essentially, is subverted to the ASEAN Human Rights Declaration, depending on how you see it, either a nightmare or just simply a bland attempt at trying to create what could be an innovative identity within Southeast Asia. I can't believe I've still got 1 minute. That's fantastic. The other story that we could tell, however, is that in fact, this conservative stance adopted by the governments themselves and the creation of an intergovernmental body that doesn't hear complaints is very consistent with the way in which governments in these situations of building regional systems are likely to react. So to quote from a human rights lawyer who was considering the Universal Declaration on Human Rights when it came into being, in the 1940s, international lawyers gave the Universal Declaration on Human Rights a chilly welcome. It was not that they were supportive of the post-war it was not that they were not supportive of the post-war turn to rights in general, but rather, for many, the legal impact of the declaration seemed negligible at best and detrimental at worst. Now, let's compare that with what Navi Pillay said to the ASEAN Human Rights Declaration. This is not the hallmark of the democratic global governance to which ASEAN aspires, and it will only serve to undermine the respect and ownership that such an important declaration deserves. Now, I think in both those instances, people have been wholly negative about the notion of this political declaration. And what I would say is that over the past 2 decades, the number of actors contributing to the process of regional integration has grown considerably in ASEAN. And most remarkable has been the growth of various civil society actors, including, but clearly not limited to, NGOs. So I think reflecting on the diversity in ASEAN, these civil society organizations comprise actors with very different roles and approaches. Some focus on specific human rights, others try to cover a broad human rights spectrum, some work predominantly at the national level and try to represent local constituencies, and others are more working at the regional or international level. And I think it's the multitude of civil society actors that are actually going to make a critical contribution to the development of the human rights system in ASEAN. Now, whether or not we can rely on human rights movements to push the agenda and engender this document, you know, rather than being this moribund end to a sad journey, to actually make it into something dynamic and interesting, remains to be seen. But I still think that we have to look to those autochthonous voices within the region to really be the ones who determine its fate, rather than judging it against a supranational authority. So, just to conclude then, like Samuel Moyen said about the Universal Declaration, the now well understood drafting of the Universal Declaration and its usual focus cannot be separated from the far larger historical forces that doomed it to irrelevance in its time. I think that one could say the same thing about the ASEAN Human Rights Declaration and the hopes that it would sort of engender some kind of utopian multilateralism have to be put to rest. But at the same time, I still have faith in the peoples of ASEAN to take this instrument and the regional proclamation of rights for the individual, both as individuals, minorities, and majorities, to the place where it should go. Thank you.
Thank you, Michelle. Yes, we have just a momentary pause here while we get this, the slides loaded for our next speaker, Professor Alacino. Stand and stretch if they'd like to. Yes, I would. It's very warm in here. Yeah, it's very warm.
Can I?
Ready?
Yeah.
Okay. Professor Alacino is going to speak to us about constitutional rights and legal systems protection of minorities.
Thank you so much. First of all, I would like to thank Professor Tognati for inviting me for this very interesting workshop. I must say that, as you can appreciate from the title, my paper is based on the relationship between personal status laws and minorities in the light of the constitutional rights, which in turn normally includes the protection of minority that, in my case, in the light of my paper, may be considered a social legal reality. I will try to explain that. For now, I must say that, as you know, this is a huge problem. which is now spreading out across the world. And this is because under the pressing process of immigration and globalization, today no country in the world has one type of people within its border. One of the most important legal consequences of this has been that the personal status law continue to migrate with groups and communities or minorities, making them more and more transnational. At the same time, around the world, many constitutions are increasingly directed towards affirming, at least formally, the respect of human rights, the principle of equality, the prohibition of unreasonable discrimination, the protection of fundamental freedom, including freedom of religion. All of this identify what may be called the transnational constitutionalism's design, which normally implies the right to be different, granting minority groups a certain degree of autonomy within a nation-state or state-nation. This group, in any case, have the right, in the light of the constitutionalism's design, have the right to preserve their identity, and many times they do so by using their personal laws. As you know, this has been a significant characteristic of Asia legal systems, so South Asia legal system, whose experience underscores the problem of the governance of religious, cultural differences, legal pluralism under the framework of the constitutional rights. But, for the reason I mentioned before, in the last decades, this has become one of the most controversial issues of the Western contemporary constitutionalism, which is constantly in the search of a reasonable balance between diversity and uniformity, or as Professor Tognatti wrote in the poster of these workshops, between unity and uniformity. Besides, this has become even more difficult in the light of the other crucial issues, like those referring to the need for a social and economical justice. In order to address these questions, various proposals have been made. In respect to the subject of my paper, most of these proposals have in common the fact that they usually fluctuate within two opposing sides of poles. One of them aims at abolishing all personal status law by adopting a top-down, state-driven, uniform civil code. The other is based on the maintenance of these personal laws that are associated with religious and cultural differences. Now, my impression is that many of these solutions suffer from the negative impact of what Gaston Bachelard called epistemological obstacles. These are obstacles that often distort the reading and the analysis of social, legal realities, and with the same frequency prevent a reasonable, pragmatic balance between cultural religious claims and the need for a concrete protection of constitutional rights. And this is already evident in the way of considering the expression personal laws. Few people have indeed focused the attention of this expression and the potential contradiction of its words. As you know, a person is an individual, so personal laws should mean that this kind of laws regard a person. Yet personal laws normally pertain to family issues, which means a person as a member of a family. Moreover, these laws concern a person not just by virtue of being an individual or a family member, but also by virtue of being a member of a religious, cultural community. In other terms, some persons can use these laws or they can be affected by them on the basis of their belonging to a specific group. For this reason, when related to constitutional rights, personal laws are often considered in the term of what Francesco Palermo calls the dichotomy between individual rights and group rights. And this, in the light of some social or local conditions, might sometimes produce what we called epistemological obstacles. For example, that dichotomy may become a conceptual obstacle that prevents people from understanding how personal law may be important for individuals in developing their personality and identity, which leads to consider these laws not only in terms of collective rights, but also in terms of the rights of the person, as our Constitution, the Italian Constitution, established in Article 2, as an individual and in the social, legal reality within which human personality and identity is often expressed. Of course, this implies that communities and their personal laws are not important per se, unless one wants to support the organic ideas of collective groups against the proper protection of constitutional rights. But even in this case, personal laws are able at least to underscore the existing interrelation in reality between these rights and some social, legal realities. On the contrary, those who strongly oppose to personal law often do so in the name, only in the name of the best interests of constitutional rights, emphasizing their individual constituencies, which somehow mirrors or reflects the opposite attitude of those who support personal laws by stressing the collective identity of a specific community. So, all of them consider the connection between constitutional rights and personal laws in terms of insurmountable conflicts. For example, those who insist on the respect of the principle of equality and the protection of human rights see religion-based personal laws as the root causes of discrimination and the social injustice. For this reason, they believe in a secular agenda based on a unique, uniform civil code established by the state. The fact is that often these same people are not always able to see that all over Asia, Africa, and even in the West, historically, personal status law have not simply gone away because states wish them to vanish. Different legal systems coexist and continue to operate, even though they are not officially recognized. At the same time, they are not able to appreciate that under the label of the unique, uniform civil code, sometimes conceal the desire of favoring one of few major groups, legitimizing a daily dose of discrimination or assimilation, if not suppression, towards those communities other than the dominant ones. Moreover, sometimes that dichotomy between individual rights and the personal laws prevents people from understanding how the system of personal laws works in reality. They, for example, are not able to highlight the fact that in some parts of the world, this system operates in the sense of a legal uniformity without having a unique codified civil code. And in this perspective, India, in my opinion, is the most important example of that. As you know, in this matter, when the Indian Constitution was drafted, some sort of compromise was found. This compromise postponed the enactment of uniform civil code, which was mentioned in the 1954 50 constitutions, but only as a direct principle of state policy. This kind of principle is not enforceable by any court. Yet this principle would require the Parliament to adopt for the future, this is very important, a uniform civil code. The fact is that until now, Article 44 of the Constitution has remained unimplemented. Moreover, soon after the independence was achieved, the Parliament moved into the opposite direction, as the so-called Hindu Code bills and a special marriage act show very well. All of this underscored the fact that a uniform civil code as a general law shared by all citizens has simply not materialized. In any case, what has emerged during these decades is the ductile, flexible practice of different models of religion-based personal law, which, unlike to what many people think, also shows that religious laws are not static at all. These laws are indeed living legal reality that, as such, interact with other surroundings realities, including those referring to the state law. This is shown by the fact that under an intricate interplay between judicial activism and legislative interventions, all Indian personal laws now look more like each other than ever. But they are still identifiable in terms of Hindu, Muslim, Parsi, and Christian laws. And this is not just by virtue of their title. It is also due to the content of their disposition. As a result, over several decades, this process has de facto gradually developed a uniform law, but without codifying a unique civil code. This is even more relevant in the light of some important case laws. You can see that those on the screen, which may be considered the milestones of this process. And we should note that this process has been taking place in a concrete manner, while Article 44 of the Constitution has always remained a pie-in-the-sky aspiration. And strangely enough, while dreaming or struggling for that aspiration, many media and scholars still remain virtually unaffected by the important outcomes of a uniform process that has developed under their very noses. It is important to note that in those case laws and within this process, Indian judges, and especially the Supreme Court, normally interpret the religious personal laws in accordance with the constitutional rights, but they do so in an indirect way. They, for example, usually do not say that some religious rules and practices are in contrast with these rights. By using the essential practice test, which has been created by the same Supreme Court, they declare religious rules and practice as non-religious, or at least non-essential characteristic of a religion. In other words, engaging themselves in an effort of scriptural exegesis, Indian judges sustain argument against some religious rules and practices, saying that they are not essential to a specific belief. In this manner, they try to reformulate religious tradition from within these traditions, while gradually building up a legal overlapping consensus. In other words, this strategy aims at affirming constitutional rights in such a way that they become less and less strange in the Indian society, more and more effective within the most important religious cultural communities. Now, the problem is that sometimes this strategy requires judges to simplify or even distort the reality. In other terms, sometimes they too aliment what we call the epistemological obstacle. This is evident when that strategy is strictly related to the definition of religious laws, the principle of secularism, and the system of relationship state churches established in some country around the world. The recent and the very famous Sharia Bano case is the best example of that. Here, the Supreme Court says that the Muslim triple talaq, recognized and enforced under the 1937 Indian Sharia Act, is unconstitutional and manifestly arbitrary. And this is also because the triple talaq is not an absolute, I'm quoting, an absolute religious practice, which means that this practice is not an essential part of the Islamic personal law, and as such, it does not deserve the protection of Article 25 of the Indian Constitution. Now, in order to sustain this position, an important portion of the 395 pages of the decision is devoted to the system of relationship state churches of the Muslim majority countries around the world. As a result, the Supreme Court gives us a classification of this system under which Algeria, Iraq, Kuwait, Libya, Tunisia, Morocco, and are all considered, quote, theocratic states, simply because all these states declare Islam to be official religion. At the same time, though, Jordan, Syria, and even Egypt are defined as a secular state, which, in the end of the day, is a clear distortion of some social, legal realities. Suffice to say that the Constitution of Egypt considers Islam as, quote, the religion of the state, end quote, and Islamic Sharia as, quote, the principal source of the state legislation, end quote. In my opinion, the Supreme Court has done that not only to make the above-mentioned strategy more intelligible, but also because it enables Indian judges avoiding having to point out the fact that the triple talaq, whether an essential part of Islam or not, is in contrast to some fundamental rights, starting with those established by the Indian Constitution. However, for the same reasons, even in this occasion, the Indian case contains some important lessons for Western and European lawyers, which is particularly true in the light of the recent ethnic religious implants brought by the immigration. Under this process, in the last decades, the legal plurality is becoming an important feature of our legal systems. Question about religion, the religion-based alternative dispute resolution, as well as the dual system, state religions, jurisdiction in Canada, in the UK, in the US, and even in France, are the best picture of this narrative. Take, for example, the debate in the UK on the alternative religion-based dispute resolution in family law. When referring to the Sharia tribunals, this debate is in practice monopolized by two opposing positions. On the one hand, there are those who want to ban religious tribunals because, as Baroness Cox has said many times, the UK, quote, the UK risks having an alternative legal systems which do not necessarily provide protection of the rights of those individuals most vulnerable to the community's pressures, end quote. On the other hand, there are those who see this ban as the faster way to push Islamic tribunals underground, where no state regulation, coordination, or legal recourse is made available to those who may need it most. Now, because it is often trapped between these two opposite positions, this debate also leads to underestimating other important factors. For example, it does not focus the attention of the difference between the Sharia councils and the Muslim arbitration tribunals. In particular, it is not able to point out the fact that Sharia councils are informal jurisdiction which do not necessarily operate under the due process of law and respect of the fundamental rights, as a very famous BBC's documentary shown in 2013, if I'm not wrong. On the contrary, this picture is taken by this documentary. On the contrary, the MAT, the Muslim Arbitration Tribunal, is an alternative dispute resolutions which is openly official and it operates under the 1996 Arbitration Act. As such, the Muslim Arbitration Tribunal is forced to respect constitutional rights, which is also guaranteed by the presence of an expert panel of legal professionals, including qualified solicitors, barristers, judges, and Islamic scholars. The fact is that the vast majority, over 19% of Muslim people using Sharia, do not choose the MAT, the Muslim Arbitration Tribunal, but the Sharia councils. And the vast majority of these Muslim people are women seeking for an Islamic divorce. The main reason for this is that normally the Muslim Arbitration Tribunal cannot deal with divorce proceedings. So, thank you. So I wonder why in the UK, instead of addressing these questions, I'm not saying that the Muslim Arbitration Tribunal is the best solution to solving the problem of the governance between unity and religious cultural difference. But I wonder why in the UK, instead of addressing these questions in the light of those real-world factors concerning the religious personal laws, and the concrete implementation of constitutional rights, people continue to debate in highly politicized terms. In other words, they continue to base their arguments only in terms of favor or against Sharia. Perhaps it is not by chance that this same political approach is also experienced in France. In particular, this is evident in relation to the island of Mayotte, which in 2011 became a French overseas department. Along with the need of reaffirming the French principle of laïcité, French principle of secularism, this change decreed the end of Mayotte's local Muslim personal laws with a single stroke of pen. The problem is that this pen did not take into serious account a religious legal reality that have been working domestically for 100 years in the island. As a result, during the 2017 general election, Emmanuel Macron said that in some part of France we could not simply deny some realities like those referring to the Muslim system of Qadis, Muslim judges like those established in Mayotte. But even in this case, the debate was suddenly monopolized by some false problems. Moreover, it was dominated by fake news, which saw Macron accused of planning to establish Sharia in Mayotte and in general in France. In conclusion, in the West, we clearly struggle with handling the new challenges of cultural diversity, which is a product of ethnic and religious implants introduced into our legal system by massive immigration from Asia and Africa. In response of the need of managing this new cultural diversity and taking into serious account the lesson coming from Asia and Africa, neither the Uniform Civil Code nor the system of different religion-based personal law may be perceived as ends in themselves. They must be considered as means to attain the better protection of constitutional rights, which implies the right to be different. Here is the essence of the pluralist constitutionalism's design that as such may induce or infers a pragmatic approach. This approach should avoid the formation of what I called the epistemological obstacles, which, as I said before, prevent a realistic management of the religious, cultural claims and the fundamental rights, including the rights of minority groups. This means that the recognition of the religion-based personal law cannot take place in a vacuum. it has to take place in a constitutional framework which, of course, is not entirely negotiable. But this also means that we should take personal laws very seriously indeed. In this manner, we may at least discover that one of the most important challenges of some social legal realities is to make the existing personal law work better for as many people as possible. And we should do that within the framework of constitutional rights. I know this is indeed a huge challenge in every respect. In any case, as demonstrated by the workshops that have been taking place during the last 3 years in this university, this problem is by no means unique to South Asia states. This is becoming a problem of Western and European legal systems, including Italy. Thank you.
Thank you, Professor Alcino. You all have been so wonderful that we are way ahead of schedule. So we don't have a fourth panelist, a fourth speaker. I'm undercharged to get everyone to coffee break by between 4 and 4:30. The question is, should we begin our discussion and carry over after coffee? Should we try to plow through with the discussion? So whatever people's pleasure is. I was going to ask whether any member of the panel would like to either ask a question of another panelist or comment on something else that was said by one of the panelists before we move on to the discussion.
May I ask a question to Michelle? Yes. I would like you to elaborate, because you said there are different views on this Asian declaration. Yeah. Well, first of all, it would be interesting to know what you think, whether in which, of the two camps you think you belong. And the other thing is about an assessment, if you can give that, as to how much of the Bangkok declaration is in the ASEAN declaration, sure, and how much instead the ASEAN declaration is inspired by Western values in a way. So whether there has been a shift in terms of ideological approach to these supposedly existing Asian values.
Those are excellent questions. Thank you. Should I just respond, or do you want to take a round?
Why don't you go ahead and move?
Okay. Yes, you're a clever man. What are my views? Well, if anyone looks me up, Michelle Staggs-Kelsall, feel free to cite. You will probably find that I had a look at an article I wrote with my good friend Christoph Sperfeld in 2014 about the declaration, and I must admit I was shocked to find that I could almost come across as an ASEAN apologist. I was really reading it going, wow, you're so positive, and you're but to be fair to myself, it was written as part of a series of articles by a Swedish International Idea for a forum that was targeting government officials. So we were trying to use that opportunity to provide recommendations and say these are ways you could use the instrument, to develop the system. But I would say in general, I think I fall on the side of the Sam Moyne / building regional system origins foundational moment crew, simply because I find it difficult to lambast Asian governments or non-Western governments generally for not adhering to a system of norms that they have to date had limited part in creating. So, I mean, if we look at certainly the human rights instruments, it's true that they were engaged in the process of drafting those instruments, but I think in terms of framing the application, much remains to be seen as to how that plays out. So as I ended in my paper, I think it's up to people indigenous to the region to really determine whether or not it's failed or not. And I think at the moment we're in an interesting time in the building of that system, because what's becoming clear is that the ICHA is kind of mimicking the ECOSOC, the Economic and Social Council, in its approach to the way in which it assumes that regional role. It issues masses of reports about human rights issues in the region. It now has a system whereby civil society can become, can get ICHA status, similar to the ECOSOC status, to be an NGO, to hear the ICHA and contribute. So this is, you know, Philip Alston, who's a very prominent human rights lawyer and writer, said that, you know, in a ideal world, the ECOSOC would be humanely put to sleep. So not everybody agrees that that's a good thing. But what I would say is that I think that if you look at it in a long-term perspective on the regional architecture, you know, there may be room for greater push toward getting that institution to have more teeth than it currently does, and take complaints from civil society. But I think we do have to be clear, even if we accept that view, that ultimately the system as currently, in its current state, is far, far from where it needs to be to protect those are the most vulnerable within ASEAN communities. So I think that, you know, it's not an apology by any means for what ASEAN governments are doing. In terms of how far it's gone from Bangkok, the really key point there is that the Bangkok Declaration continued along the lines of non-interference and non-intervention in ASEAN member states. And the declaration does not include that. So they have taken the position, arguably, that we have supranational authority to invoke human rights and to say human rights are, you know, across the region, indivisible, and we as an entity and as a group of nations now agree that human rights have supranational authority. So that, I think, is a win. Sorry for hogging the microphone.
No, thank you. I'm going to take Chair's prerogative here and ask a follow-up on that. So just going to the Bangkok Declaration, to what extent do you think the current declaration, ASEAN Declaration, does reflect Asian values?
I mean, that's a tricky, that's a tricky question. I hesitate. Yeah, I hesitate. I mean, Asia has to be the largest minority in the world, right? Like, I hesitate to answer that, because I don't think you can, you know, I think traditionally that's been associated with the notion of economic, social, and cultural rights as taking priority and being paramount, and, you know, Asians are most concerned about poverty eradication and, you know, ensuring that we have food in our bellies before we start to think about this notion of civil and political rights. I mean, I think if you ask the majority of people within, like the man on the street in ASEAN, you might get a sense that that was still the case. You know, this is an interesting question, because, you know, I think there is a sense amongst my Khmer friends, emerging middle classes, certainly, that's really important, right? I want the right to work. I want to have money. I'm very happy to have my mobile phone and, you know, my moped or my moto, and I need to feed my family. So is that particularly Asian? Is it to do with emerging middle classes globally? I can't really tell you, but I think that, yeah, I find it difficult I hesitate to say yes, they're still apparent. But I think there is definitely arguments to say that, you know, those values are still very important to people in the region.
Other people on the panel, do you have a question for either? Do you have a question for either of them? Just because we have 6 minutes to cover, yes.
Oh, wow.
Oh, you piled on here.
Yes. Yeah. It's in the... Yeah. That's true. Right. Maybe non-European. Yes. Again, I hesitate to say Asia, you know, per se. Yeah, do you want to?
Go ahead.
No, go. Yeah, I mean, I think that's right. I think look at the. There was some discussion about whether it appeared at all in the Universal Declaration, and I think you're right. I don't think it did appear. I think duties don't appear, but there is another part of the general. Does it appear? Yeah. So there was an argument that you know, because they were adopting a similar form to the Universal Declaration, that actually it wasn't that distinctive or different from the European experience. But you're right that it doesn't, obviously it's not in the convention. So, I mean, I hesitate to sort of culturally specifically say, oh, this is an Asian thing, we all believe in duties, you know, it's really important. I don't know, I'm more inclined to say possibly more communitarian, yes. But there are elements of the Western notion of rights. You know, Joseph Raz, sorry to raise Raz, but he would probably argue for communitarian notions of rights anyway. You know, so again, it's hard to say that's particularly Asian, but certainly family and nation is what I saw as really being, you know, where the duties get invoked in the Asian context. Yeah. Thank you. Yeah.
Everyone has duties to the community in which alone the free and full development of personality is.
Right, right. So there was, you know, in some of the commentary, like Catherine Renshaw says, you know, actually, it's not, because civil society was up in arms in ASEAN, you know, oh, yet again, you're invoking this notion of us having to be dutiful rather than, you know, subordinate to the state and to the family, to everything else. But, you know, I think arguably it's not that dissimilar to what happened in Europe.
Well, just if I may add, it's true that in European tradition, of course, individuals are generally only right bearers and not duty bearers. When it comes to minorities, however, there are, you know, some provisions hinting to that, more or less soft. Well, of course, we all know the Spanish Constitution when it comes to the language, for example. But also some of the soft law documents, not the most modern I was referring to, but even the, you know, one now 20 years old Oslo recommendations by the High Commission on National Minorities on linguistic rights of national minorities starts off by saying, well, persons belonging to national minorities have the duty to know the state language, which is, you know, already kind of a deviation from the traditional approach. So the problem is that while in Asia, probably this idea of duties, again, as you quoted Article 29, very much affects the whole of society. In Europe, it normally goes only to minorities, which can easily, you know, become a way of coercion of minority position, saying, well, you have duties and you have to know the state language, but not the other way around. You have to do this and that, so you have to be loyal. You have, and you know, the whole dynamic I was referring to before. But there are some references to duties also in European documents, I would say.
Minorities must be recalled that they are legitimate.
So, shall we continue with our discussion, or would you like to break it? Break. Welcome back. Before we get started for the last phase here of our discussion, Professor Amarante has an announcement that he wants to share with us.
Okay.
Accende da sotto.
Okay, thank you. Thank you very much. I'm responding to a request by Roberto to make a couple of announcements about what we are doing in Campania University, and of course the collaboration with Roberto is a long-term collaboration. And in the light of this, I'm very happy, I'm glad to announce this program that we are organizing in September, also for the students that might be interesting. It's a postgraduate summer school on comparative law in the age of globalization, and the specific theme is contribution from the global south to the contemporary debate on legal theory. And this year there will be a general part and a special focus on environmental law, climate change, and all related problems. It will take place in southern Italy, in Paestum, near the Greek temples, and it will be a week near the beach also. You can go from the temple to the beach directly. But I will be very vigilant. I won't let you go to the beach. No, so we are congregated for a week, but mostly with PhD students, but also non-PhD students are welcome, up to the number of 20 students maximum, because we want to have a ratio of almost one professor, one student. So it's from 17th of September to the 23rd, one full week, and with not only presentations by professor, but also presentation of PhD project or PhD thesis, if there are PhD theses completed, that will be discussed by the professors and by also the other students. So it's a sort of PhD tutorial course also, because we will also present some books and discuss them with the PhD students. So it's a very interactive summer school. Professor Toniati will be one of our leaders in this summer school, as well as from India, Professor M.P. Singh, and from UK, Professor Werner Mansky, and a number of other professors. It is organized with other universities. Mostly is Indo-Italian cooperation with the National Law University, Delhi, India, the Rajiv Gandhi National University, Patiala, and also the Jindal Global University. So the venue would be at the Vico Foundation. Vico is a famous Italian philosopher, at the Vico Foundation. So that's for the summer school. So if someone wants to participate, you just have to write to me. Maybe you can get the contact through to Professor Toniati, and maybe I can circulate a short program to all the members of the conference. Let me also announce a second opportunity for students wanting to enroll in our PhD, because I am also the director of a PhD in comparative law in the University of Campania. And every year we offer 2 scholarships for foreign students. So especially for foreign students, that could be a good occasion to get a scholarship, full scholarship for 3 years for enrolling in this PhD. Of course, if you apply, there's no security to get the scholarship, but we really would like to have good application and good students to apply for that. So that's another opportunity. EU and non-EU. They doesn't have to be Italian, only non-Italian, let's say not Italian. Of course, since we have an approach very open to overseas countries, maybe the projects they present will be favored towards with respect to European projects, but there's no exclusion. We accept, for example, last year we had an Indian student, Sakilendra Pratap Singh, that will maybe present at the summer school his project on climate change. Don't know if it's good enough he will present, but otherwise I won't let him. And another, the other student is from Spain, so Malaga. So there's no. Yes, for the PhD, if you want to to participate to the competition, the evaluation is only on curriculum, while the Italian students have to pass and have written an oral examination to get the PhD. Well, okay, that's finished. Then I want to make a question, but I don't know if I do it now or later.
You can do it now while you have the microphone if you want, and then we'll
Okay,
ask further
okay.
questions later.
So no, the question is for Professor Alicino. Thank you very much for your very interesting paper, and where you showed the interest of the very pragmatic approach to the relation between personal status, religions, and law in a pluralistic, in a plural legal system like the Indian one, and also the relevance for Europe. So, in the light of your paper, I would like to ask you, first of all, if in your judgment on the pragmatic aspect of the Indian Supreme Court on the personal status, if you have considered also the way Supreme Court plays with time to deliver its judgments, and because in the story of the judgments of the Supreme Court on this subject, time has played a very important role. Let's say they have left the issue to calm down for some years. For example, in the Shabano case, this is very, very evident. So also on the Talak case, I think the period on the triple Talak case, the period was chosen with care. And so starting from this example, and from the fact that you are proposing to take some lessons from this experience, what are your proposals de jure condendo for European constitution, and in particular for the Italian system, for trying to introduce elements of the Indian system, not really of the Indian system, but of the Indian attitude, of the pragmatic attitude towards such problems into the Italian order. I think the idea of secularism is not very far. The conception of secularism that we have in Italy is not very far from the Indian one, even if they have been built in a completely different legal environment, but it's not very far. So maybe you can just have some proposals in that respect. Okay.
On the end,
We're going to let our discussant discuss and then raise questions.
I take
we'll
notes.
take that
I take
question.
notes.
Thank
Thank
you.
you. Thank you.
So our discussant on this panel is Angelo Rinella, and he's going to help us make sense of all of this.
Thank you very much. Just to introduce some subjects, but in a special way, first of all, I would like to thanks to Roberto Tognati. Congratulations for this very interesting conference. My speech, in order to introduce the discussion, will be strictly connected to the last part of the speech of Professor Alicino, because I would like to, following a pragmatic approach, I would like to draw your attention on the Muslim minorities in Western legal systems. In a special way, the problem of the Sharia tribunals and Sharia courts. One of the most significant impacts of the new interconnectivity in the global world system, especially in Europe and North America, is the introduction of a significant number of new residents of Islamic background. Western legal systems developed during the Enlightenment, which have traditionally separated religious doctrine from law and public policy, are faced with a new set of circumstances, whereby some residents of Islamic background elect to solve civil disputes according to the principle of their faith rather than the conventional procedures and rules of civil law. While some members of the Islamic communities of Western countries have recourse to informal Sharia religious courts, some Western countries have taken steps to formalize supervised Sharia councils as recognized legal arbitration courts, whose rulings may be enforced by the ordinary justice system. Predictably, this has caused controversy in some circles, as some members of the public have raised concerns about the implication of faith-based arbitration systems being integrated into standard legal practice. The questions are, could the Sharia courts represent an instrument to guarantee the fundamental rights and freedoms of Islamic communities because they are minorities in Western countries, even if cumbersome? Are there any problems with the compatibility between the rules applied by the Sharia courts and the Western legal system in which they operate? The relationship between law and religious tradition in the traditionally defined Western world has, since at least at the time of the Enlightenment, has been one of the mutual awareness, as jurists have fiercely debated the definition and limits of religious freedom, and viewed with skepticism the interaction between religion and government, particularly when that interaction involves the encroachment of religious ideology within secular law and the interference of secular law with religious liberties. Since the social and legal upheavals of the Enlightenment, the question of whether religion should play an explicit role in legal procedures has been largely regarded as settled, as most Western nations have adopted either formal or informal concepts of this separation between church and state. Likewise, the influx of immigrants from traditionally Islamic nations devoid of the cultural heritage of secular legal thought has led specifically to demands that citizens of Islamic background be allowed to rely on Islamic law and customs rather than the secular laws and customs of their adopted countries. While other religious groups within these nations, such as Catholics and Jews, have long-standing arbitration courts of a similar nature, the Sharia courts have been the focal point of activist campaigns against such faith-based arbitration courts. Sharia is literally the way, that is the law that God revealed in the Quran and which is binding on all Muslims. The ambiguity is that Sharia has never been implemented anywhere in the world. What is implemented are different interpretations of Sharia, what are called Muslim laws, al-fiqh. The problem of the Islamic communities and of the observance of the Sharia sought ways of solution, above all in common law systems. Mainly two ways. The first one, entrusted to the work of the courts through the technique of reasonable accommodation. The other one, through the Sharia councils or Sharia courts, thus activating a sort of judicial autonomy, which does not affect the monopoly of the state jurisdiction, but places itself in respect of it in a subsidiary or supplementary position. Regarding the role of the courts in the common law system, the examination of the jurisprudence shows, in general, the ability to resolve controversies that recall norms of religious metrics. The difficulties that characterize the processes of integration of Islam within Western societies, especially from a legal standpoint, are mainly due to that cultural and religious identity considered to be prejudicially not reducible to the values of Western constitutionalism. On the other hand, the constitutional principles of Western democracies ensure that the equal treatment of cults and the freedom of every individual to choose and profess their religion. The courts act in a cultural and social context that necessarily orients their interpretation of positive law. Judges' decisions and jurisprudential guidelines are not formed in the sidereal vacuum. The legal system is not impermeable to the social context. If society presents a multi-ethnic, multi-religious, culturally heterogeneous structure crossed by migratory flows and demographic variables, the legal system and its interpreters cannot remain indifferent to it. For these reasons, in some legal systems, the courts have applied the principle of reasonable accommodation. According to this principle, the contrast between rights and freedoms guaranteed by the Constitution can be resolved by the constitutional interpretation, also by way of derogation from the general legislation in force. In order to protect the rights of those minorities, very often characterized by religious identity, which, if constitutionally guaranteed in the abstract, may then be subject to unjustified limitations. The reasonable accommodation or mediation made by the judges tends to eliminate the distorting effects of the principle of formal equality and the non-discrimination that erga omnes rules can produce when they are applied to subjects who claim their own identity rights. Parallel to these judicial orientations, the tendency to create a para-jurisdictional system, in fact parallel or subsidiary to the official one, for the resolution of disputes among members of the same religious community has gradually been affirmed. A formalized Sharia arbitration system would offer certain benefits for new citizens of Islamic background, namely a familiar form of law for recent Muslim immigrants not acclimated to the secular court system. For example, in the United Kingdom, public protests against the perceived imposition of Sharia law on British soil have garnered the support of both nationalist groups, such as the English Defence League, and self-described moderate Muslims under the banner of the One Law for All organization. Other British Muslim organizations have publicly demonstrated in favor of the Sharia arbitration courts, contended that there is nothing inherently immoderate about the forms of Sharia practiced in the West. Proponents of the Sharia courts in the United Kingdom point out that under the Arbitration Act 1996, alternative forms of dispute resolution are both legal and enforceable under higher law, and that there is no precedent for excluding Sharia courts so long as all parties agree to abide by its rulings and the rulings don't violate British law. In the context of Western constitutional democracies, scholarly interpretations of Islamic law display a great variety. This has led, understandably, to mixed reactions within Western countries with the growing populations of Muslim citizens. In the debate over the formalization of Sharia law, the Islamic community has been subject to frequent accusations that is attempting to illegitimately import foreign cultural customs into the framework of Western law. Sharia courts and Sharia customs in general, these commentators argue, are components of this culture of inequality and must therefore not be permitted equal status under the laws of Western countries. According to this vision, the integration of Muslim immigrants in Western liberal democracies is particularly problematic and in most cases unlikely. The reasoning behind such a perception finds its most articulate form in the European debates and is expressed in the form of 4 axiomatic statements. The first one, Muslim immigrants tend not to integrate into host societies. The second one, this lack of integration is the product of a conscious decision. The third one, this decision is made because the goal of Muslim immigrants is to dominate rather than to blend into Western societies. And fourth, there are no variations within Muslim, no extremist or moderate, and no conservative or liberal distinctions. At this point, it is necessary to underline some issues. What future perspectives for Sharia in the West? Given the current political dynamics and numerous ongoing political crises involving the Islamic world, the future of Sharia in Western democracies is mixed. In Canada, the elimination of religious courts in Ontario precipitates a general ban. Likewise, the rise of nationalist sentiment in the United Kingdom combined with Brexit may pose a challenge to the existence of Sharia tribunals as campaigns against them continue. Unlike in Canada, however, there are few indicators in the United Kingdom of an immediate legal threat to the continued operation of Sharia courts. In the United States, the state legislatures of many states have voiced their displeasure to the presence of Sharia in any context of the legal system by passing laws attempting to remove foreign or religious law from the state courtrooms. However, courtrooms relying upon the legal doctrine of neutral principles tend to sidestep First Amendment concerns by focusing on the contractual aspects of religious arbitration agreements, treating them like any other agreements. Furthermore, the two-pronged legitimacy offered by case law and the Federal Arbitration Act would appear to indicate that arbitration courts, Sharia courts included, are likely to be a part of the US legal landscape for years to come. Second point, are Sharia courts compatible with secular democracies? Taking into consideration the wide diversity of religious perspectives falling under the umbrella of Sharia law in the Islamic faith and the legal tradition of Western nations, Sharia courts are arguably compatible with secular constitutional democracies, provided that they receive the proper oversight due to all arbitration courts to ensure their rulings are in accordance with the laws of the nation they operate in, and the parties whose cases are heard in the Sharia court are recoursing to it of their own free will. Historical examples and modern diversity of thought within Islam demonstrate that fundamentalist values are not inevitable within Sharia systems. Sharia arbitration courts, if properly monitored by the authorities, should present few difficulties to a secular democratic system. A large debate is happening within and among Muslims who are living in the West. At the heart of this debate is a quest for possible religious and theological grounds that would facilitate a peaceful coexistence with not-Muslim majority population in immigrant-receiving countries. Implicit in these efforts is the belief that for such coexistence to materialize, there is a need for Muslims to revisit and revise some of the fundamentals of their beliefs, or at least the beliefs that have been considered fundamental till now. Everybody knows that there is no unified and authoritative interpretation of the Sharia. Different versions are in effect in different countries, and interpretation also varies from mosque to mosque. In Western countries, Muslims who come from all over the world have a multiplicity of religious affiliation, particularly those who belong to the second and third generation migrants. In the context of social engagement, it's possible to group the Muslim communities in different typologies of interpretations of Sharia and way to consider their relationships with the host societies. Assimilationists, integrationists, separatists. Just the first two groups deserve some consideration in this context. Assimilationists are those who want to adopt local customs and ways of life, to do in Rome as the Romans do. These people may not identify first as Muslims. They embrace a secular, national, or ethnic identity, while distancing themselves from former religious expression. It seems that Islam and Sharia law have a little relevance for secular Muslims. Integrationists. They wish to take part in the society, but without sacrificing aspects of their religious identity. On the one hand, they wish to retain their Islamic identity and continue their Islamic practices and customs. On the other hand, they seek to engage with civic and secular authority in the West and to navigate their interpretations of Islam within existing frameworks. The most important example of integrationists is those who propose a new jurisprudential approach known as Fiqh al-Khaliyat al-Muslima, the jurisprudence of Muslim minorities. This title refers to a growing body of Islamic legal rulings and conceptualizations that emerged in the latter half of the 90s, thanks to the contribution of some Muslim scholars, and aim to addressing the particular challenges faced by Muslims who were living in non-Muslim countries. The basic premise of this new school of thought is that the realities of the lives of the Muslim living in non-Muslim countries are so fundamentally different from those of the Muslim majority nation that the traditional Islamic jurisprudence cannot offer meaningful solution to their problems. There is therefore a need to establish an entirely different jurisprudential approach as the basis for the solution to the problems faced by Muslim minorities. The legal system of a multi-ethnic, multi-religious, and multiracial society cannot avoid dealing with the legal pluralism that is determined in the social reality. The presence of religious authorities called to manage disputes among the members of the same faith community is now a widespread phenomenon. In conclusion, the first sentence highlights the following points. The first point is that Islamic communities rooted in the territory of many Western countries show they want to preserve their cultural and religious traditions, invoking the application of Islamic law to matters pertaining to the person, in particular family life. Second, according to the legislation in force in several countries, particularly in the common law systems, the matter of arbitration, the parties can freely agree to resolve their dispute according to Islamic law. Of course, the assumption that legitimizes this choice is that it has been accomplished by both parties in complete freedom. Third, the work of Islamic courts in a non-Islamic state must tend to seek ways of accommodation between Islamic law and the law in force in the state, in order not to incur in the annulment by a state court of the arbitration award pronounced. Fourth, the question of the violation of fundamental rights remains open. Rights that are not in availability of individuals. No woman can renounce to receive an equal treatment or to fully exercise her fundamental freedoms. At the same time, no one can be forced to behave in ways that break his or her own religious beliefs. In invoking the universal inviolability of human dignity, could the Western jurisdiction impose on person a behavior contrary to his or her religious beliefs, even when the latter was incompatible with the fundamental rights of the person? A multicultural society probably requires a multicultural jurisdiction. the path taken for some time now about the elaboration of a jurisprudential interpretation of the Sharia for Muslims living as minorities in non-Islamic countries represents, in my opinion, a path destined to produce results in the medium-long term. On the other hand, ostracism towards the Sharia courts and the Sharia councils does not seem to favor the strengthening of a dialogue. Rather, the control mechanism of the work of these bodies should be perfected, and the instruments for reporting violation of the fundamental rights of the weakest subjects should be developed. Thank you for your attention.
Thank you, Angela. So I want to first ask, Angela, do you have any questions for the rest of the panel at this point, for Professor Alicino? Okay. You've already got one, right? Yeah. So let me ask generally, before we start to lose any more people, if people out there have questions that they would like to pose to the panel, any members of the panel, and to the panel generally. Professor Toniati. Yes. Okay. Okay. I'm sorry. Okay.
Sometimes affirmative action can be also discriminative. Being a woman doesn't mean that.
You get to go first.
That's what my husband always said. Thank you very much. I'm Ljubica Đorđević. I'm Senior Research Associate at European Center for Minority Issues. From my background, I'm a constitutional lawyer, or I used to be one, but I have to say that I have very, very limited knowledge on Asia, so I'm really sorry if my questions are somehow not very competent. But nevertheless, they are part of my curiosity, so I'm curious to ask. I have two questions or two groups of questions. One question goes to Ms. Stax-Kelzal, and it's about the declaration. This is my ignorance is, although it's a declaration, it's a hard law, it's a legal instrument, yes or not? And if it is a legal instrument, I would be curious how is the effect in national legal orders, and if individuals can call for the norms in the declaration or not. If it's only a political document, then how are the resonance in the national? Did they have any effect on and provoked some changes in national constitution or all national legal orders in the countries, state parties or however? And the other group of questions go to Professor Alicino. It's about this legal pluralism, which is really very interesting. And here I have the question about individual autonomy. To what extent individuals can choose whether they want to be under these personal laws or state laws, or they are just because of belonging or put in some boxes they have to be under the personal laws. And about India, which I don't know, is there then the areas which are under personal laws, are there also alternatively state laws, so that if personal laws are not applicable, then state law applies, or there are various numbers of personal laws, so that there is actually, is it legal pluralism vertical or also horizontal, if you understand what I mean? And also, can a state influence the legal pluralism or legal autonomy through interfering in about who will judge it, about the institutions who then deliver justice under these systems? And finally, on legal pluralism, how it is in international private law. If something is under, in national system, is it then recognizable in other states according to the principle of international private law? Because there have been some cases in Germany when German court says it's against German law, so divorce under Sharia, although it's non-German non-German citizens, but German court says it's not divorce under our system. So this how it's in this international public, or is it recognized then in other legal system? Thank you very much.
Thank you. Let's take a couple more questions and then we'll throw it to the panel here. So, yes.
No, I think that my voice is enough. No, I need the microphone, okay, because I have some problems with microphones. So, a question for Francesco, a request to Francesco Allicino. Can you please better explain the Indian Supreme Court approach to the instant talaq and the triple talaq? So how they approached these two different instruments, personal laws. Then the second one, it's almost a personal question. So do you still feel discriminated as a non-Bumiputra to Michelle? This one. Oh, okay. Yeah. I was looking at you, but I don't know if you. No, I'm so sorry. I was trying. I was trying to be really fast. So, no, because Michelle, this is just a question, just then to shift for shifting to Francesco Palermo for the other observation, because Bumiputra, the literary translation is son of the land, I guess. So there are some particular kind of minority groups that they must be linked to a particular land or territory. We're not talking about, for example, sexual orientation now, but if we talk about ethnicity or we talk about languages, so we are talking also about the land. That is for, I think the easiest way to, the first association that you can make between minorities and then the state power. So this sort of link must pass through the land. So now the question for Francesco Allicino. So Palermo, I'm so sorry. Francesco is fine. He can reply for you, maybe. So a statement that you made before during your presentation. If the, please correct me if I'm wrong. If the nation state is not the best feasible way today, thinking about a regional nation has no credibility, right? Yeah, this is approximately your idea about. So you were talking about federalism in this case. So I can agree on this when the regional experience show a minority group that has a sort of sense of belonging to institutions. But the point is that there is a sort of centripetal force, okay, that is just inside any single ethnic or linguistic group. So this is to link to the other question, no? So, and sometimes it happens, as Professor Tognatti, for example, talked about an autonomous region in Philippines, no? And they shared common values, common religion there, and also other cultural aspects. So, can you better explain that statement? Thank you.
Marco had a question as well.
Yes, I would also like to address Professor Allicino with regard to the judges of the Supreme Court of India, yeah? Because I think this is a very important position, yeah? to be a judge at such a court. When you try to completely transform a millennia-old cultural tradition, yeah. So my question goes more to the training and of judges. How is it possible to achieve this transformative function, so to speak? Yeah? Is there special training of judges? Is there awareness that the training of judges not only in British common law and ways of education is necessary, but also this cultural, political, social awareness raising, and is there something like that, yeah, in the background? Second question to Professor Rilnella, and this is where I wanted to follow up with the first question. international private law has been mentioned, and are you aware of different case law from different European countries? How this ordre public provision according to international private law is completely differently interpreted by courts. Just to give an example as an idea, the Austrian Supreme Court upheld a decision of an appeals court granting social security and access to hospital treatment to 3 women of 1 man. So polygyny was not declared against ordre public in Austria, for instance, by the Austrian Supreme Court. And this might be interesting. The reason for that was we want to protect the women, otherwise they would have no access to health care. So it's more important for women to have health care for women instead on insisting on a very abstract doctrinal question. This was the reasoning of this Supreme Court decision, and my final question goes to Francesco. And again, maybe that not everybody knows here in the room that he had been the president of the advisory committee under the Framework Convention for the Protection of National Minorities for some years. So my question simply is, are you now pessimistic about the results and the future of the entire instrument, or do you think it is worth going on to be attached to these ideas and the underlying philosophy, and maybe say, well, in the next couple of rounds of supervision by the advisory committee of the implementation of it on the ground, things might change again. So let's remain optimistic a little bit.
Thank you. Professor Neo.
Thank you. So I actually had a similar question to Francesco about the Framework Convention, because you talked about the sorry, what's it called? The Ljubljana and the 2 other documents, so the 3 documents, the TC4 and Ljubljana guidelines and so on, and which focuses more on integration in diverse societies. But I'm just wondering whether the sort of underlying, the foundation of minority protection under the SCNM, the assumptions that are made, can really be so easily sort of jettisoned in favor of a new approach. So very much like the question. Michelle, I agree with you, of course, on everything. I just thought I would like to sort of get your views on whether you think further ASEAN integration will bring about greater focus on human rights and therefore sort of solidification of human rights in ASEAN, or whether human rights will be an impediment to greater integration. So really the relationship between integration and human rights in ASEAN. Because of course Singapore is right now the chair of ASEAN, and they have made these big statements about, aspirational statements about how we must integrate and we must do more to integrate ASEAN. But one big sort of elephant in the room is, what about human rights? And of course, the Rohingya situation in Myanmar is a huge problem. Lastly, for Professor Alcino, Stanley Fish has a piece which he calls boutique multiculturalism. I don't know if you've heard about this piece. Stanley Fish, of course, likes to be provocative. But I think there is something there about boutique, what he calls boutique multiculturalism, which he sort of describes as this idea of multiculturalism of ethnic shops, multiculturalism of accepting that you can go to an sort of Exactly. But at the end of the day, when it comes to questions of whether we accept Sharia laws as personal laws, there's always a question of whether there will be what happens when there's a conflict with constitutional questions. So someone like Kim Lika, for instance, in talking about liberal multiculturalism, says that, well, ultimately the constitution must prevail. But then that raises the boutique multiculturalism critique, which is that if the constitution always prevails, then what space of autonomy are you really giving? So personal laws then become problematic because it's basically personal laws as dictated by the state. So in terms of religious freedom, in terms of religious autonomy, that doesn't quite sound like real autonomy to some people. Yeah. So I wondered what you would think about how we can resolve these conflicts in a way that really gives real bite to autonomy for religious groups. Yeah.
Thank you. Professor Toniati.
I apologize. I have myself 3 questions. In fact, I had 5, but I'm only asking 3. In order, Francesco Palermo. I would also make reference to your experience as chairperson or president of the advisory committee. And the question was, in the monitoring instruments, did ever occur that the violation of religious freedom has been raised within the Framework Convention? In other words, do the issues of religious minorities pop into the Framework Convention, which is not mainly meant to cover those kind of issues? Then, Michel, would you say that the ASEAN Declaration includes freedom from religion? And does it include the freedom to change religion? Now, we heard this morning that in Malaysia there is legislation which prohibits conversion. And certainly one of the main differences, I mean, this is a very picky point if you like, but certainly I would say in any European country, conversion is always a personal matter, which remains within the boundaries of your own conscience. It never becomes a public issue. And this is not the case in some countries. So how about the declaration? Does it include freedom from religion and freedom of conversion? Then Francesco Alicino. Now this, you will hate me for this, perhaps. But my question is related to India. Perhaps I should ask Nico Amirantes, or he will hate me too. Now, considering Article 44 of the Indian Constitution, the state shall endeavor. So it is not an obligation to have a result, but it is an obligation to make some steps in order to. So this is not justiciable. But there is an obligation to endeavor. The state shall endeavor.
For the parliament.
Yes, that's right. So my question is, do religious communities have a right to a regime of personal laws? And also, considering that there is also a quarter of the population, which in Singapore is 17% of people not belonging to any religious community, would you say that agnostics or atheists have a right to state legislation which replaces religious rules that they don't consider that it is for them? So this is my question. Is there a right to personal laws, in particular taking into consideration the rights of non-believers, if you like? Then I have 2 more, but I think I should stop here. Thank you.
Thank you. Those are all great questions. I don't know who wants to. Do you want to just go down the order of the panel? Francesco, would you like to begin?
Shall I? Okay.
why don't you? And then work our way down the table.
Okay, let me start with issues related to the Framework Convention as such, and then I move to the more general question by Pasquale. Well, first of all, let me start with the last one. Roberto, religious minorities under the Framework Convention. There is, of course, an article protecting religious rights of persons belonging to minorities. We all know that, well, religious aspects are very less relevant in Europe than they used to be, and where they are or would be relevant, these groups are normally not recognized under the Framework Convention. It's typical the issue of Muslim groups. So there are cases, but they are very marginal. They normally affect two areas. One is in the Orthodox countries, the role of the Orthodox Church, which is very dominant, which has an institutional implication, and sometimes either contributes to create a climate of intolerance. Well, a case that comes to my mind is Georgia, for example, or when the Orthodox Church is seen as a sort of a fifth column of a kin state. Yeah? The interesting case of the Romanian Orthodox Church in Serbia and to what extent it can operate, etc. But apart from these limited cases, I would say not much, in fact. Yeah. As to the Framework Convention more generally, so Joseph and Jacqueline, well, perhaps starting with Jacqueline, you asked basically to what extent is an interpretation possible of this instrument, right? Which takes it in a kind of a different direction as compared to the original intent. Well, that's a similar debate that we all know from constitutional law. So to what extent is constitutional interpretation admissible? Well, we know that there are broad margins. And my point here with regard to the Framework Convention is that originalism doesn't help, right? Exactly like in constitutional interpretation, also the interpretation of the convention according to the original intent is not helpful. So a more societal approach is definitely more important. So if originalism doesn't help, constitutions do. And therefore, this leads me to Joseph Marco's question. Well, of course, I'm still optimistic, but I believe optimistic in the sense that this is the only instrument we have, so we better make the best possible use of it. The problem is that, unlike constitutions, this is an international treaty, and this relies on the action by many other actors. It's not a purely internal matter, and it's not self-executing. So it requires, for example, cooperation by states, and it is kind of understandable that states are very reluctant conservatives. What I understand much less is the suspicious attitude by international bodies themselves sometimes, but they are in the hands of the states, and also by several minority groups. Because if you take this poverty approach rather than richness approach, so minority rights are making societies poorer and not richer, then of course minorities tend to be very jealous of their small piece of cake. And therefore they are not following very much on this interpretation, and many, especially the most powerful minority associations, actually push towards the other way. Say, no, let's adopt a very strict limiting approach and start with the definition, and possibly the definition should say that only we are minorities, therefore only we have access. So, yes, it is definitely worth going on with a convention, but perhaps taking a slightly different interpretation. And finally, the question by Pasquale. Well, we would need an entire conference only for that. And actually, we did have some, like Joseph and Roberto, they both participated. It's about the ownership of the land. As Roberto also said this morning, of course, there is some common driver. Yeah, there is this kind of equivalence with the nation-state dynamic. It's the same driver. You know, we are a group, or we believe that we are a group, and we want to own a territory, right? That's normal. I have tried to do some inquiry comparatively, but I never came to a conclusion about, for example, the very origin of territorial names and a name of groups. We have so many cases like of endings in land, stan, Pradesh in India. They mean the land of, right? But I've never been able to find out whether the name of the people originates from the name of the territory, or the other way around, whether that territory means it is the ownership of that people. So this is something which is anthropologically based. It's normal, it's natural. I don't contest that. I just say that, oh, by the way, if we take the federal regional states that have been established, I will say, well, the last 100 years, they are all based with that idea. And the number of federal states has increased enormously. So, in fact, this is a very popular idea, and there is some truth in it. The problem is that by using territory only as a means to accommodate some group using the idea of collective property, because that's what it is, undermines the potential of territorial self-governance. Because then you end up having exactly the same problems that we have at the level of the nation states, where you have to accommodate others. And territories are never homogeneous, territories are always diverse. Nowadays, even more than in the past, of course, because of mobility, migration, what have you, changes of borders. Yeah, well, in a way, it's just reducing the scale of discrimination, but that's what is happening. Well, in a way, it's the pendulum, yeah. This is also normal in human history, that there is a pendulum. Now we take revenge because now we are in charge and you have discriminated us, and now we discriminate you, etc. Okay, that's all human, right? But I think... Yes, but... Some cultures don't have... Don't have? Pardon. Yeah. No, but I think this is just part of the discourse. When it becomes the whole of the discourse, then it gets problematic, because it is based on a fictional reality which is not mirroring the reality. So you then undermine even minority claims, because then you kind of create illusions that then this minority can be given a sort of a second best option to statehood, which is partial statehood, but ownership of a territory, and then they end up being disappointed because it's not entirely their property. And then, there are limits, etc., and then you start a negative spillover. So it is an important stuff, very important. But when it becomes exclusive, then I have a problem. Let's put it this way. Yeah, it is.
Thank you. Francesco, would you go next, please?
Thank you. Thank you. Thank you so much for your very interesting, very difficult questions, indeed. Professor Amarante talked about a pragmatic perspective and the role of the Supreme Court is a political role. I think, yes, this is shown by the fact, by the time the role, and you can see that not only with the very famous Sciabano case in the 1986, but also in the last case, Bano case. But this is, I think, is related to the questions of a personal law. As I said, in the last decades, especially the Supreme Court has played a very important role in changing the way of viewing, way of considering the personal law. And the strategy is very important, and this is related to the way of considering and the principle of secularism, which is very different of the principle of laicite. You cannot, the strategy is based on the fact that the Supreme Court many times says that some religious practices are against the Constitution, but they say that in considering these religious practices, these religious prescription or rules, saying that these are not essential part of that religion. This is based on the essential practice test, which was created in the 1965 by the same Supreme Court. So, you know, and this is explained by the Supreme Court itself, saying that, you know, there is an Article 44 of the Constitution, but the Parliament doesn't do its job, so I'm forced to replace the Parliament in this way. And I'm going to do that with the instrument I have in my hands, and the instrument are the personal law. But we, I think, in this case, we must, it is important to remember that we are facing personal laws, religion-based personal law, codified by the state, and this was a colonial project, because most of this personal law was codified before the independence. After the independence, there was the process of Hindu code bills, but before the independence, we had always a Christian personal law about the family issues and so forth. The lesson coming from India is important for me. Italy, yes, and not, because, you know, in Italy there is a strange way of considering the principle of secularism. Even in this case, the supreme principle of secularism was established by a judgment, a very important judgment issued by the Constitutional Court for the first time in the 1989. The Constitutional Court said that the supreme principle of secularism is one of the most important supreme principles of our constitutional tradition. But in this case, we have to consider that this principle of secularism is very different from that established by the French tradition, where there is a strict separation between religion and the state. So in Italy, you can explain the fact that we have a dual system jurisdiction, but also provided for the relationship between Catholic Church and the state, while other religious organizations are forced to sign an agreement, the minimum agreement called the Intese, established, even in this case, by the Constitution, paragraph 3 of paragraph 3 of Article 8 of the Italian Constitution. The fact is that the problem is now, this is related to the Islam, which is the second religious organization in Italy, but Islam is simply not recognized. And Islamic organizations in Italy are forced to live under a fascist law, a law established in the 1999. So the problem in this case is the instrument of what is called the bilateralism legislation. That legislation which is established by the Article 7 and Article 8 of the Italian Constitution, which worked very well in the past. I mean, when the Italian religious geographies was monopolized by few religions. But now this bilateralism method doesn't work anymore. So we have to find other ways of managing or the difference, the problem of the difference between the new religious geography in Italy. In this case, we can draw some very important lesson from the Indian experience. The other question was legal pluralism in India. Can individuals choose between personal law or the state's law? Now, as I said, in India there isn't a uniform civil code. So there are many personal laws based on the religious issues, which were codified, as I said, by the state. And this was a colonial project because the English judges, they were not able to control during the colonial period, they were not able to control some religious organizations that are very important in India. So they try to do that, codifying with the help of some expert, codifying a single, for each religion, a single personal laws. We have, in the 1954, a special marriage act was approved. This act can be used by, for example, non-believer. And in this case, I jump to the question of Professor Tognatti. This is a very important question because this is important not only for India, but also for some, for example, Muslim majority countries. The protection of constitutional rights of non-believer. This is not related to the fact that I'm not a non-believer, but it's also related to the fact that if you look, for example, in the West, there is a trend towards a recognition of no-believer organization. Take, for example, the case of Pastafarian, which has been recognized as a religious organization in New Zealand, in Norway, in Denmark, and they now have the same status of religious organization. In India, I think I don't know if there is an organization. The problem has not posed yet because I think there isn't a huge no-believer organization. So far as I know, there is, yeah. But okay. The other question was Pasquale. How Supreme Court is react to the Triple Talaq? Triple Talaq was declared unconstitutional in the Sharia Albano case, but was declared the triple. Yeah. But the problem was related to this judgment was related to the triple talaq et bidda. So for this reason. Yeah.
But there are other forms of triple talaq which still allow that marriage can be made back. They allow resolution of marriage.
Mm-hmm.
It gives chance. But instant triple talaq, which is effectuated by the from the point when it is uttered by a man to a woman. That was the only form of triple talaq that was invited.
Yeah.
Not the triple talaq per se.
I know. In any case, the Trento Constitutional Court, if you compare, for example, the Shah Bano case and the Sharia Bano case, is to say that this kind of Sharia laws are against the Constitution, and they normally say that this, in any case, are not essential part of Islamic tradition. For this case, in this case, they are not cannot be protected under the Article 25 of the Constitution in the collective sense of the term. So, in this case, Article 25 is related to the freedom of religion. Freedom of religion in the individual sense and the collective sense. So, if you look the trend, the triple talaq in this case, in the last case, was related to the triple talaq and the recognition of the fundamental rights of women within the family and within the personal Sharia personal law. So the trend is based on this issue. As I said, yeah. Yeah, I know.
In the arena of personal law. Personal laws are on one level, at the level of fundamental rights, according to the Indian Supreme Court jurisprudence. But at the same time, they are like, there is a proviso. It says that personal laws are the fundamental rights, but they are protected by health, morality, public order, and other fundamental rights in body.
That's the problem issued by Professor Toniati. There is a right for a personal law, or there is a right for non-believer. In this case, I think the question must be solved seeing the balance, what I called a pragmatic, a rational balance between constitutional principles. Because if you look the Article 25 of the Constitution, there is a trend established towards freedom of religion in individual sense of the expression, but also freedom of religion in the collective sense of the trend. So we have to find a pragmatic balance, a rational balance between these two fundamental rights. Because, as I said in the beginning of my presentation, the problem is that the constitutionalism's design is based on the fundamental freedom, which implies the right to be different, which in turn implies the right of minority groups to be different from other minority groups, and this can be achieved by protecting some fundamental rights. But the problem is that but this is a problem of the constitutional in historical sense of the constitutionalisms in historical sense of the sense. So Professor Marco said the role of constitutional judges within the Constitutional Court. I don't think there is much difference between how they are selected in India or from, for example, the selection made in other Western legal system. Normally, they used to hear some legal expert, for example, in Islamic personal law or the Christian personal law, and so forth. But in this case, it's true that if you look some debate after the decision I mentioned before, the 2017 decisions, debate broadcasted in the Indian television, some judges were accused of being Indus nationalist, and this is very important in relation to the Article 44 of the Constitution, because after the BJP political party came to the power, many human rights activists struggled for having a uniform civil code, but the Uniform Civil Code was a very important part of the BJP's electoral manifesto. For this reason, after that, this same activists, they say, no, look, stop, because we risk having a nationalist Hindu Uniform Civil Code. In this reason, we can continue with a personal law using the judicial activism, trying to reformulate some religious traditions, some religious rules within this from within this religious tradition. So what I call the social legal reality. Even also because, as I said, you cannot erase personal law with a simple stroke of pen, because, in this case, you risk to push this, for example, Sharia tribunals and this personal law underground without having a possibility from the state to control how these the human rights, fundamental rights, constitutional rights are protected within this organization. In India, this become a very important issue. If you look the geography, India is a continent, it's a huge continent. In some part of the continent, as I said, the religious organizations are very important. These are social, legal reality, where the state's law doesn't have a possibility to enforce, to be applied in this organization. So, in this case, you can, and this, I think, is the problem, is spreading out through the massive process of migration and globalization, even in the West. Take, for example, the case of alternative dispute resolution, or the faith alternative dispute resolution, as Professor Rinella told us before, and not only in the UK but also in Canada. And I showed during my presentation the case of Mayotte, and the Qadi system, Muslim Qadi system in Mayotte, and what happened during the 2017 general elections. So I think I'm not sure that I answered all the questions, but I stop there.
Thank you very much. You answered a lot, I would say. Michelle.
Thank you very much. Well, we started with the women and we shall end with them. I shall be short and sweet. In response to your question regarding the legality of the declaration, I argue that it is legal in accordance with Article 2.1 of the ASEAN Charter, which states as follows, in pursuit of the purposes stated in this charter, ASEAN and its member states affirm and adhere to the fundamental principles contained in the declarations, agreements, conventions, concords, treaties, and other instruments of ASEAN. So you could argue, using 2.1 and the declaration, that member states have an obligation to actually implement the declaration. Now, the question then becomes, given a number of member states are parties to international human rights conventions, what merit do we get from something like this, given in some cases, as I pointed out in my discussion of the individual, who is she in ASEAN, she actually gets less rights than she would under the international system. I've argued in other articles that it could be a potential midway point between if innovative lawyer didn't want to upset a particular court in a particular jurisdiction by using Western, conventions to make an argument, they could use the declaration to continue to sort of entrench or enforce an argument they're already making. For example, freedom of religion in Indonesia, and the blasphemy cases could be one example of that, where the courts in certain circumstances have been very anti the human rights arguments being made. So it is arguably a legal instrument. A lot of people would say it's a political instrument. Either way, no one has used it. Clearly no one's reading my articles. Anyway, do I feel discriminated, Pasquale, as a non... Yeah, so this is a little bit of a personal aside. You're all quite tired. I feel terrible taking up your time just telling you about me. But essentially, I consider myself what I would call a fern. I have very shallow roots in a lot of different countries. I've spent about 15 years of my life in Southeast Asia, 20 years of my life in Australia, and I won't give away my age, but there's a couple of other years there where I've been in America and Europe and other places. So home for me is no longer territorially based. It's about where the people I love are, and they're everywhere. So do I feel discriminated? No, because I have so many wonderful Malaysian friends who, make me feel completely at home. But I digress. Back to the issues at hand. Jacqueline, your question. Yes, look, my fear with regard to human rights vis-a-vis ASEAN integration, that's a brilliant question, and I think the response I would give is it is amenable. A certain kind of human rights is very much amenable and supportive of economic integration. But that's where I would argue we have to be careful of that kind of human rights being the rights that we're actually protecting, i.e. trade-related, market-friendly human rights. Is it the human rights that becomes a box-ticking exercise for certain kinds of multinational corporations who have an interest in investing in countries in Southeast Asia and ensuring that supply chains are, above board and everything's working well? So harnessing the grassroots, the original notion of human rights, as many have discussed in the Enlightenment period, in the Universal Declaration, in the sort of 70s upsurge of rights, a push for rights. I'm not sure whether ASEAN integration as currently envisaged will allow for that, or the push towards that. Because as you know, ASEAN also has this habit of sectoring everything off into pillars. So where we want that attention is in the pillar for, or where it gets the great attention is in the pillar for socio-cultural peoples, the ASEAN peoples, but that pillar is segregated from the economic community and the political security community. So in a way, you feel like we need to integrate within the ASEAN, the ASEAN pillars themselves before we can really see the push forward that we would want for human rights. So sadly, not a particularly happy picture from me on that front. Then your question, Roberto. Yes, well, you're sitting next to the expert on this question, of course, who's written this brilliant article on this very issue. I think if you look at the text of the declaration, the answer is, I think, basically no. ASEAN includes, does the ASEAN declaration include freedom from religion and religious conversion? What the declaration says is you have the right to freedom of conscience and religion, period. You don't have the right to profess it. You don't have the right to teach it. And you don't have the right to convert. Then there's this very strong statement of, all forms of intolerance, discrimination, and incitement of hatred based on religion and beliefs shall be eliminated, which I think was a pushback from certain sectors of the group who were working on the declaration to say, we do not want to allow for, certain member states to allow for violence within religious communities. But again, it's a very status notion of how that gets administered. So ultimately, it's up to the state to decide. But yeah, no supranational right, in my view. So thank you very much. I've really enjoyed that discussion. It was fantastic. I have more questions, but I'll ask you in the break.
Thank you. Actually, I'm going to give Angela the last word, if you would like to.
just a point, because Professor Marco spoke about the role of international private law. I didn't mention the international private law because I know that it's very complicated to explain in which way it works in the courts, in the civil courts. But anyway, I think that, as you said, that the possibility to recognize, for example, a polygamy from a point of view of the social rights, this is a question opened. And it depends. It depends on the constitutional interpretation. Okay. Then the role of the courts is very important in these cases. And I think that it is better to examine case by case. We don't have a general principle in front of this problem.
Thank you. Any final words? Thank you to the panelists. They did a wonderful job, I think. And thank you to all of you for coming and for staying on this long day.
Professor Toniato wants to say something.
Professor Toniati. Oh, that's a really good idea. Thank you. I'm sorry. There is a third session for everyone that doesn't know that.
Sorry.
Amelia, can you just for a moment? That's okay. It's my fault. I forgot to mention that tomorrow morning there is the final and third session. I just want to remind everyone from 9:30 tomorrow morning. Do come. It's going to be really interesting. So do come tomorrow morning. Thank you. And thank you, Robert. I'm sorry I forgot that. Got caught up in the conversation at the end.